SJC-13527, Commonwealth v. Scott W. Morrison.
Okay, Attorney Bradle, whenever you're ready.
Hello, Your Honor. May it please the Court, Your Honors, Timothy Bradle on behalf of Scott Morrison. My client is doing a 25 to 30 at MCI Norfolk under the aggravated kidnapping statute. Your Honor, the Court has granted further appellate review, and Mr. Morrison is incredibly grateful for that and thanks this Court. The issue here, Your Honors, is that the statute under which he was sentenced is undeniably ambiguous, and he must be given the benefit of the rule of lenity. And if the Court does not do so in this case, Your Honors, it will work catastrophic injustice on Mr. Morrison, who will spend the rest of his life, likely spend the rest of his life in prison over a statute that we're not quite sure what it means. And no one wants to be part of a system where someone...
Help us, tell us what it means then. So,
Okay.
from what I understand, there are 3 levels of kidnapping.
Yes, Your Honor.
There's kidnapping armed with a dangerous weapon, and then we get into this, and that has a greater sentence.
That's right, Your
Then
Honor.
we get into this third category with the armed with a dangerous weapon and thereby.
Right. Thereby is the rub here, Your Honor.
My first question, though, before we get into grammatical parsing, why does it make sense that your client, because again, I look at the legislature, they're not a bunch of grammarians. They're focused on policy distinctions. So your client is armed with a gun, he kidnaps, and the result is death of the kidnapped victim. So why does it make sense that the injury basically doesn't matter at all here in your client's case? Just tell, is it all because of the word thereby?
It's a very fact-bound case, Your Honor. It's a convoluted set of facts, and
again, the legislature's writing in categories, so it's dividing into 3 categories, and you're creating a sort of, in my view, a 4th category.
Okay.
So I just want to understand why that is.
Sure.
Because, again, I don't find either of the 2 decisions below that helpful in elucidating meaning as opposed to grammar.
Sure. The answer, Judge, is found in a close review of the facts, the scope of the joint venture, Your Honors. There's a joint venture that involves Mr. Morrison, allegedly, and found by the jury, to have kidnapped the deceased while having a gun on his hip. And then he is alleged to have delivered, or found to have delivered the person to the principal here, for lack of a better word, Mr. Feeney, and then leaves. There's no contradictory evidence that he was there, that he was part of this. And so that's where his joint venture ends for now. Feeney takes it upon himself to murder, and that was his verdict, murder Mr. Robertson.
Let me take it, let's go a little further. Mm-hmm. So your client is armed with a gun and a baton, right?
Well, that's a fact question, Judge. The baton was in a duffel bag in the car.
So but if for example, he gave the baton and the gun to Mr. Feeney, and then Mr. Feeney used them, I take it we're in your view, you get the 25 to 30 years, right?
If he gave the baton to Feeney, Your Honor?
Yeah,
well,
and Feeney used it, he's part of this joint venture, I take it he still gets 25 to 30 years.
No, Your Honor, because I'm finding refuge from the jury verdict on that. He was only found guilty of manslaughter, not sharing the intent to murder. He was only found guilty of manslaughter, which is a statement by the jury that he did not share the intent to kill or cause grievous bodily harm.
I'm looking at the statute, okay?
Right.
So the statute, your focus is on the word thereby.
Yes.
And again, if he'd used if Mr. Feeney used the gun or the baton that your client had, I take it 25 to 30 would meet the statutory language, right?
No, because he did not use the baton, Judge. I think the jury found that that's probably part of the verdict, Your Honor, is that the baton was in a duffel bag in the car. I forget if it was a trunk or the back of the car, but nonetheless, it cannot be said that he was armed with it. So the focus needs to be on the gun, and it's undeniable that the gun caused no harm whatsoever.
You're totally focused on your client, which is absolutely what you should be doing. But we're also focused on we've got to interpret the meaning of this statute,
Right.
Which applies to a lot more people than your client. So
Right.
I'm just trying to make the statute make sense, and you're not helping me much on that.
Okay, let me try, Judge. So the statute, the legislature has seen fit to add the word thereby, not by means of, which I know counsel for the Commonwealth wants to focus the court on, words that are not in the statute, so immaterial. So here, the legislature has chosen to use the words thereby. And so I want to invite the court to look back at Justice Sachs's dissent here, where he slices and dices the opinion, the majority opinion, pretty well.
He
Where
slices and dices grammar.
yes,
But no one's giving us an explanation of why the legislature would want to treat this differently, that it's so important. Again, the example, I can't remember if the majority uses it or the Commonwealth uses it. He kidnaps him with a gun and then strangles the victim with rope. It's the same result.
but it's a different person, Judge. He was definitely found to not be participating in that.
Keep focusing on this narrow factual issue, which again, your prerogative, but help me make sense of the statute, at least.
Sure.
try.
It's the fourth paragraph of Justice Sachs's dissent, Your Honors. He says that the word thereby can plausibly be found to modify either inflicts, well, strike that, I'm sorry. It's found to modify inflicts, but then you still need to go the next step. What's being inflicted, a kidnapping or use of a dangerous weapon?
So that's my question
There's the
for you, is that
ambiguity.
in the other paragraphs of this same statute, thereby is also used, right?
Yes, Your Honor.
And in those paragraphs, thereby clearly refers to the crime of kidnapping. And I'm wondering why it shouldn't also be interpreted or construed in this last paragraph, the third paragraph, to modify the crime of kidnapping.
Because it doesn't make sense, Your Honor, and it's redundant. A kidnapping causes a harm from a kidnapping. It doesn't make sense. If you just read it,
I don't understand that. What do you mean it's redundant?
Why would the legislature have to refer back to the kidnapping? We're already talking about a kidnapping statute.
But we don't have a serious bodily injury in any of the other paragraphs. So that's what's added here, right?
Yes.
The first, as Justice Kafker was saying, it's a sort of an increasing set of punishments for additional conduct.
Sure.
First paragraph is just kidnapping. Second paragraph is kidnapping while armed with a firearm. And then we come to the third paragraph where you're armed with a dangerous weapon and there's a serious bodily injury thereby.
So all Mr. Morrison needs is a plausible reading to create an ambiguity, and then it's game over for the Commonwealth, Your Honor. Here,
Well, that's why I'm wondering, usually we don't interpret sentences in any statute in isolation. We usually interpret them in the context of the statutory scheme as a whole.
Sure.
And in the other two paragraphs, thereby refers clearly to the crime of kidnapping.
Well, I believe thereby was added later, Judge. In the appendix, we have the November 5th, 2010 version of it, which I'm focused on here. And I think it's not I don't think it's a controlling word, Judge, because when you look at the third paragraph that's applicable here, what inflicts serious bodily injury? A kidnapping or a dangerous weapon? And the logical reading of it is a dangerous weapon. And as Justice Sachs says in that dissent, the word thereby can equally plausibly be referred back to either a kidnapping or a dangerous weapon.
Can you, sorry, just.
That's, you know, as they say in the opinions, you need go no further. There's the ambiguity.
Go one step, just when are you done? Yeah. Thank you.
Sure.
Yeah. So I want to try to wrestle with the policy question, because again, I think that's, the legislature's focused on policy,
Sure.
not grammar. So why would a kidnapping while armed that results in a substantial bodily injury, in this case death, not be subject to the highest penalty, the third prong, because the weapon that he used, the gun, was not what inflicted the injury? Why would the legislature make that distinction when, again, there's a substantial injury, a kidnapping, and you're armed? And this thing wouldn't have happened, maybe it would have because of the cleverness of the constables and the, you know, they've got police documentation they shouldn't have, but why would the legislature want to penalize this less, even though there's a substantial injury here?
The legislature is bound to their words, Your Honor.
But I understand the wording. The wording has been expertly diced by the appeals court. Tell me why that makes sense.
I feel like that's speculating, Your Honor, because I need to stay with the language of the statute.
Words mean something in the real world. They reflect reality. So
right.
Why would the legislature want your client to get less time, even though the person who was kidnapped is dead?
He wasn't held responsible for the death, Your Honor, in the sense of murder. He was held responsible for manslaughter by recklessly creating a situation. So he wouldn't apply to the statute the way Your Honor appears to be contemplating it.
Well, I'm just trying to make sense of the statute.
I mean, the reading that Commonwealth would have would be that someone's abducted using a handgun, taken for a ride, and then beaten.
Right.
Correct? And your view is that wouldn't satisfy the statute. The Commonwealth's view, it would.
Well, it depends on the facts, and this set of facts is extremely unusual, Your Honor, where it's established conclusively that Mr. Morrison was told, and the other co-defendant, Richie, was told that there was going to be no.
I know, but you lost that with the jury. So the
Well,
issue.
no, I don't think I did, Judge. I started to cut you off. I don't think I did, Judge.
Let me. The question I have is, that's what we're really struggling with. The legislature could say, when you abduct someone using a handgun, and then the consequences that follow if someone is severely beaten so as to inflict serious bodily injury, we're going to punish you further.
Right.
Then you read on in the same sentence, and it says, whoever sexually assaults such person, there's no thereby in that. It could be someone is abducted and then they're sexually assaulted. That's an aggravating factor for aggravating kidnapping, right?
Well, that's the Rodriguez case, Judge, where the statute has already been found to be subject to the rule of lenity in that respect, where the sexual assault aspect of it, the defendant in Rodriguez got the benefit of that. And, you know, as Justice Sachs again says in his dissent, it's not surprising that the language here is troublesome. And just want to, if I could just account for all the different interpretations, Judge, and this is why Morrison has to win this, Your Honors. We have Judge Cosgrove. He found that thereby modified the word commits. Then we have the majority of the appeals court saying that it modified the word inflicts, but then went on this grammatical lark and found that it was not ambiguous. Then we have Justice Sachs agreeing that it modifies the word inflicts.
Sorry, counsel, could we go back to the sort of practical question here? So we've been discussing and wrestling with a hole that would be created, I think, to use one of my colleagues' words, in the hypothetical not existing here of, you know, someone's killed with a rope, not the weapon. If the court were to accept your interpretation and interpret the statute as you suggest, how would a case like this be charged? Would there be a way to account for the whole, as it were?
I think the court needs to charge the way that I asked Judge Cosgrove, I was trial counsel, Your Honor, that I asked Judge Cosgrove to charge, which was that the-
Apologies, I said charged by, when I said charged, I don't mean by the jury, I mean the prosecution, because obviously they will want to hold someone criminally responsible where they strangle someone with a rope and not the gun they came with. So could you address that question?
It's just like Rodriguez, Your Honor, that unless the legislature does something different, that they have to say that the dangerous weapon causes the injury.
So there are no other crimes that the person could be charged with to deal with the rope?
Like murder.
Well,
Sorry, I'm just asking, we're wrestling with the practical difficulty and the strangeness of
it's a
the
very strange
legislature's...
set of facts. It's a very fact-bound case here, Your Honor.
Well, it's fact-bound for your client and important for your client, but we're trying to make a rule for future cases, and this statute is certainly going to apply in future cases. And so we're trying to figure out how we should most sensibly interpret the statute, and we're wrestling with the fact that your reading would say that the legislature in this statute has not penalized people who show up with a gun, but then the person is killed with a rope. So could you explain how, is there a way, because this is not addressed in the briefs, is there a way that that situation could be accounted for by the fabric of the rest of our criminal laws that is not apparent from the briefing here?
Sure. It's really the facts here where it's such an anomalous set of facts where he's found to have taken the person away while having a gun on his hip, and that's the instrumentality.
I agree the facts here are fact-specific, but I don't think it's necessarily unusual that there'll be multiple weapons at a crime scene and that someone may bring one of them, but then that's not the weapon that is used in the crime. So could you address the more general situation?
Sure. So here, Morrison leaves, and he's not there for the encounter in the garage, for the murder in the garage, just to put an exact point on it. And he's summoned back to help dispose of the body, is what the finding is. So here...
But that's not a necessary fact in many future cases, because under your reading, even if...
It's not going to come up in future cases.
If let's just imagine Mr. Morrison stayed, which we know he did not, but say Mr. Morrison stayed. Mm-hmm. Under your reading of a statute, he still could not be charged, correct? Because the gun was not used to inflict the serious bodily injury, which is not disputed here.
I think he'd be on the hook as a joint venture of being present at the scene, absolutely. So this really wouldn't cause a glitch in the law. I think that the best point here for Your Honors is to hold the legislature accountable where it's just like Rodriguez, they create this ambiguity. Either interpretation is plausible. I know Your Honors, you do it for a living. You solve problems, you solve cases, you give the answer. But here it's a little different. Your job here is to see if there's an ambiguity.
So the view that you have on joint venture would be that if someone abducted someone at knife point, and then there was another guy there that had a baseball bat, they're taken away, and the person with the baseball bat hits the person, it doesn't matter because they're all going to be guilty in a joint venture.
Right, it wouldn't matter in most cases where it's a joint venture.
Of an aggravated kidnapping.
And the weird thing here, Your Honor, is that he was explicitly not part of that part of the I don't want to say the joint venture. He was not part of that transaction in the garage. He was found to not be that by the jury. And that's the funny part of this, the strange part of this case. And that's what should get him the rule of lenity as applied here, because in this weird set of facts, troubling and tragic set of facts, no doubt, he was not part of the use of the baton in the garage, did not share the intent for that. And if you look at the statute, each of those interpretations is plausible. And that ends the inquiry. And the rule of lenity here, as applied to Mr. Morrison, should carry the day, Your Honors. I say I'm over. If there's any further questions, I'd be happy to answer them.
Okay.
Thank you very much.
Attorney Summer. Alford, I'm sorry. I'm so sorry. Thank you.
Good morning, Your Honors. Pamela Alford for the Commonwealth. The Commonwealth asked this court to affirm the defendant's convictions for aggravated kidnapping, manslaughter, and conspiracy involving the kidnapping and death of James Robertson. It is not correct to say that the defendant's conduct ended when he left the garage.
But does it matter? I mean, let's stick to the statute. Thereby, it sounds like creates an ambiguity in this third paragraph. And as your opposing counsel has said, isn't that game over for the Commonwealth? Once there's an ambiguity, the rule of lenity kicks in, and the defendant can't be convicted under your interpretation. Or are you saying that the construction advocated by the majority of the appeals court is the only construction of thereby?
It is the plain and logical reading. There is no ambiguity in the statute, and there is no, and under this court-settled case law, there is no need to use the rule of lenity because the legislature was not ambiguous. The intent of the legislature is clear, and while it's not necessary to get there, to use the rule of lenity in this case would produce an absurd result.
What about Rodriguez, where we said that the rule of lenity applied within the same sentence? On the last part of it, on the
I thought Rodriguez was an appeals court case. I could be concerned, but the Commonwealth's view is Rodriguez helps. Rodriguez says that armed with a dangerous weapon.
I'm sorry, it is an appeals court case, right.
But as I said, the Commonwealth's view is that Commonwealth versus Rodriguez is an argument in favor of the Commonwealth of how to consistently treat this statute, that armed with a dangerous weapon modifies both the inflicting serious bodily injury and the sexual assault. So here, if you took the defendant's interpretation, you would be saying that you have to commit the serious bodily injury with the dangerous weapon, but that you'd only have to be armed with the dangerous weapon for the sexual assault. That would be an inconsistency. To address Justice Wendland's question, the use of thereby is consistent. Thereby was first used in the kidnapping or a predecessor kidnapping statute. I tracked it back to 1901. And what was the first paragraph? And it clearly went to the offense of commits. It was predominantly used with an aggravated offense for intent to extort. And in 1998, when the legislature put in that statute, they put in 2 new paragraphs, and one was kidnapping with, the second paragraph became kidnapping armed with a specified firearm or other specified firearm type weapon. And then the sentence of, and if there is intent to distort, thereby.
What do we do with all of that legislative history? I mean, it's all very quite interesting, but is the ordinary person out there supposed to understand and know the legislative history in order to interpret this, what I think might be ambiguous language? Are they supposed to say, oh, well, in 1892, they did this, and then, oh, so they must be, by thereby, they must have always meant the commission of the kidnapping and not the DW?
The 2 interrelated answers to that. Judging from the person armed with armed with a dangerous weapon has a very specific meaning, and has had a very specific meaning for, I would suggest, well over 150 years.
And I would suggest it's the literal meaning of being armed with a dangerous weapon. My question is not about armed with a dangerous weapon. It's about the inflicts SBI thereby. Right, that doesn't have a specific meaning from time immemorial, and it doesn't, as far as I can tell, have a specific plain and ordinary meaning in the sentence, in that paragraph, unless I pull in, well, what did the legislature probably intend? You know, what happened in the legislative history? And I'm wondering, in that situation, where I have to rely on these non-plain and ordinary meaning sources, who wins that battle? The Commonwealth, who's written a statute that requires these other things in order to interpret it, or the defendant, who is just looking at the words of the statute?
I respectfully do not accept the premise that this is ambiguous, because my suggestion is that what the legislature did here, and the dissent pulls what he called a snippet of legislative history, and I think that it helps the Commonwealth that originally this was an omnibus firearms statute. And in the House, they put in some language that would put in the second and the third paragraphs. And the first version of the third paragraph had "with a dangerous weapon." And then what the conference committee did was they put in what we now know to be the statute, which was both consistent with using armed with a dangerous weapon. And the legislature, the second part of my answer to Your Honor, is that the public would read the statute to say that armed with a dangerous weapon has its long-standing meaning, and the legislature is presumed to know how this court has held. And this court has held for many, many years in a variety of both statutes and both in terms of statutory interpretation and in double jeopardy analysis, that armed with a dangerous weapon means to possess it but not necessarily actively use it. It is the defendant's interpretation.
The problem is the enhancement comes from the injury, right?
Yes.
Because we've already got the enhancement from the armed with a dangerous weapon. That puts you into category 2, right?
Not necessarily, Your Honor. So paragraph 2, the Commonwealth's interpretation is that it has to be a specific weapon.
In this case, it was a firearm, though.
In this case, it was a gun. So in this case,
And are you saying it doesn't fall under paragraph 2?
The Commonwealth would say it does not fall under paragraph 2 because there was a search of Feeney's, the co-defendant's residence. They did pull a 9mm that possibly was the firearm, but there was not testimony that you would need to prove the statutory definition of a firearm, that the barrel was under 16 inches, that it was capable of firing shot. That wasn't the evidence that was available to the Commonwealth.
The Commonwealth loses this appeal. What's the consequence for this particular defendant?
There would be a lesser included sentence of kidnapping.
Okay, thank you.
But here...
Now,
Okay.
You're saying he wasn't armed with a dangerous weapon?
No, I'm saying if you look at the second paragraph,
Doesn't the third paragraph have the same armed with a dangerous weapon as the second paragraph?
No. Your Honor, respectfully, I don't believe that to be the case. I believe that the second paragraph discusses firearm, rifle, shotgun, I believe machine gun.
So what's the dangerous weapon that the Commonwealth is saying he was armed with?
The holstered gun that gave the defendant and his co-defendant, who was a cooperating witness at trial, Ricky, that the defendant had a holstered gun that gave him the perceived lawful authority of a constable. And using that constructive force of the holstered gun, got the victim, who was doing the innocuous activity of trying to fix his parents' sink.
Understood. Now, so you're saying the holstered gun, even if it's not a firearm, that's the dangerous weapon
Absolutely.
he was armed with, even if it wasn't operable and all of that?
And that's a very important point, because if you go back to armed robbery cases where this principle is even more entrenched. If you go back to Commonwealth versus Mowry, which is an 1865 case, and Commonwealth versus Rogers, where the firearm was never even produced, it's the possession of the firearm that increases the risk of harm. And this is the principle that the legislature would have been aware of and that the defendant is ignoring and trying to suggest that there is an ambiguity.
Okay, I have a question about the thereby.
Mm-hmm.
What's it there for?
It's there to connect the infliction of a dangerous weapon, the infliction of serious bodily injury to the commission of the offense in that statute, here kidnapping while armed with a dangerous weapon.
Can't you do that without the thereby?
I'm not suggesting it has great meaning, but it does have meaning connecting the two.
But it's not necessary to connect the two. It's superfluous.
But if it's superfluous there, it's superfluous in the first two paragraphs of the statute. The statute is consistent in the use of thereby in those first three paragraphs of the kidnapping statute that relates an aggravating factor back to the commission of the offense.
A while ago, you cut yourself off, but you had started to say that if we follow Attorney Bradle's interpretation, the defendant's interpretation, that it would lead to an absurd result. You didn't follow up on that, but I'd like to follow up on that.
Well, and this goes...
If I could just get the question out.
Absolutely.
So if I could get the question out? Thank you. But in this case, when you look at what the jury returned for the verdict, the manslaughter verdict, why would it be an absurd result for us to read that ambiguity in the way the defendant says? Because there was no evidence that connects whatever Mr. Morrison did in bringing the victim to the house to what ultimately happened. So why would that be absurd? Wouldn't that be consistent with reading it that way? Because he brought the victim there, and whatever Mr. Feeney did was something that the jury found that Mr. Morrison and the other co-defendant had nothing to do with other than disposing of the body.
The Commonwealth respectfully disagrees with that factual premise. The facts of this case were that the defendant and Richie brought the victim into Richie's garage, where by prearrangement that this defendant was a part of, there was a chair bolted to the floor. And there was evidence from Richie, who was a cooperating witness, that Morrison, he believed, brought the drill to do this. So the chair was there. Feeney comes in. He's dressed in black. He has a black ski mask. He's carrying the black duffel bag that was in this defendant's car.
Sure, all of that being true, but Mr. Morrison leaves, whatever happens, and there was testimony about the fact that Feeney was just upset. Maybe he wanted to scare the victim and to not be dating this woman or to stay away from this woman. Again, with all of the evidence that the Commonwealth adduced at trial, the jury still returned a manslaughter conviction against Mr. Morrison.
Which the Commonwealth would suggest is entirely consistent with an aggravated manslaughter. First, kidnapping is a general intent crime. So the intent that needs to be shared is the intent to restrain, to confine, but a general intent crime. The aggravating factor is the injury. And here, once they got him in, Feeney shackles the victim to the chair. Richie sees the black baton on the duffel bag, and Feeney tells Richie and Morrison to get out, to leave. So the jury certainly could find that, as they did for manslaughter, that there was a high degree of likelihood of serious injury here. This is also absurd because, to take on a legal premise, to answer both your question, to build off of Justice Stewart's earlier question, you don't even need another weapon. The aggravating factor here is the serious bodily injury. It doesn't, the injury is, the harm is the same. The victim here is dead no matter whether a dangerous weapon was used or not. It wouldn't even need to be a rope. If somebody under the influence of a gun...
But would a jury have to specifically find a joint venture theory for that to be true?
For aggravated kidnapping?
For what you're saying, for aggravated kidnapping, that shared intent runs all the way through, irrespective of whether or not you thought that they were going to use the gun or some other implement to affect the serious bodily injury.
I apologize if I'm not answering this correctly. The kidnapping did not stop when Morrison left. When he left, the victim, who was continually restrained, the restraint was continuous. This wasn't an abandonment. The jury certainly could find that the defendant was there and willing to help. You know, he came back much later at Feeney's behest.
This is not brought as a joint venture, right? There's not a joint venture conviction on the aggravated kidnapping, correct?
Well, so this was post-Sinetti. The jury was given joint venture instructions and supplemental joint venture instructions that they needed to determine joint venture as to each defendant.
Did they convict him of joint venture aggravated kidnapping or not?
There wouldn't have been a specific, the jury was not asked to make a specific finding that it was joint venture or not. As I said, this was post-Sinetti, and that they found that the defendant's conduct, whether as the defendant, either as a principal or as a joint venturer, committed aggravated kidnapping. And under the facts of this case, in the plain language, in the consistent interpretation of the word armed, that was entirely correct, and the Commonwealth would ask that you affirm the verdicts.